Greetings and salutations to all my fellow sovereigns. Tonight we'll be going over due process. So what is it, and a brief history and overview. So in chat, I put in the mega folder, and tonight we'll be reading from a treatise on the law of judicial writs and process. And this is a treatise from 1895. And so this treatise is written before they started messing up everything as far as the common law was concerned. This was the heyday, if you will, of the best ways to run the common law courts in America. So we're going to start with a history of both Roman civil law and English law, which some of you may have listened to before because I believe that I've covered this one section, but it's always good to have a review. So we'll do that. And every single time that I'm going to come across a vocabulary word, I have taken the time to pull the vocabulary words from Bouvier's Law Dictionary and put them into the chat bubbles, into the PDF itself. So everybody who downloads this PDF of this particular treatise will be able to automatically have the vocabulary words right there. And so you don't have to go stop and looking them up. Okay, without further ado. A treatise on the law of judicial writs and process. Chapter 1, historical introduction. Roman law, English law, and little conclusion. Section 1, the Roman law. The history of writs and process is essentially a part of the history of judicial procedure. The earliest type of which was a mock contest, each of the claimants laying hold of the object in dispute, like a cow or a slave or whatnot, thus symbolizing a conflict for the possession of the property in controversy. This was called actio sacramentum, and seemingly for the reason that a certain sum, meaning money, gold and silver, was solemnly consecrated to sacred purposes in pursuance of a challenge by each party to the other to stake a sum of money upon the truth of his assertion. And the funny little thing about all of that, of the aspect of consecrating to a sacred purpose some money, they put the money into a locked case. So the defendant would put his money in, the plaintiff would put their money in, and that was what they were putting up as surety to the truth of their assertion. And because they put it into a case, that's literally why to this day they still call it filing a case, because it's what's going into that case. So, to continue. In this most ancient of proceedings among the Romans, the appearance of the defendant was voluntary. The state exercised no power, save that the magistrate interfered in the feigned quarrel by calling out to the disputants to let go their hold, thus interposing the authority of the state for the peaceful settlement of the controversy. Then, the disputed question was referred to what? Arbitration. So, in the beginning of Roman civil law, there were no judges. There were only magistrates that actually acted as arbitrators. Now, let's go back up and go over the vocabulary here. So what's a writ? So let's open this up, and I'll scroll this down for you guys so you can see what it is. And these are all going to be from Bouvier's Law Dictionary, the 1856 edition, the one that I suggested everybody get their base knowledge from. So writ, practice, a mandatory precept including the authority and in the name of the sovereign or the state. Notice that it says in the name of the sovereign or the state. So in America, are we sovereign? Yes. So can you write your own writs? Yes, technically. And people used to until the corporate state started messing around and merging law and equity, and then merging law and equity with maritime admiralty and all of the rest of this nonsense that we have going on right now. But case in point, and in the name of the sovereign or the state, for the purpose of compelling the defendant to do something therein mentioned. 2, it is issued by a court or other competent jurisdiction, right, say like the sovereign, and is returnable to the same. And okay, so returnable. When you issue out a writ, you create the writ, it gets signed, it gets sealed, and then it's given to a officer, and that's usually from the standpoint of being the sheriff. So the sheriff then has to return the writ, saying that yes, he served it, and then on the back side of the writ or some other piece of paper that he would attach to it, what is now called a affidavit of service, and say, yes, I went to this guy's house, I served him on Sunday or Monday, whatever time, and gave it to him directly, and he would write that down and then sign it and seal it and say, yes, I swear that I did this. So that's and is returnable. So when you're talking about the return, that's what they're talking about. They're talking about service of process. It is to be under seal and tested by the proper officer and is directed to the sheriff or other officer lawfully authorized to execute the same. Writs are divided into 1, original, 2, of men's process, this means middle process, and 3, of execution, which is the final writ that gets issued from the court when everything's done and the matter's been settled and you have to go get your cow back. There are several kinds of writs, some of which are listed in the VSOF class folder on Mega. And so what I did was I made a list of what is stated within the section of writs under Bouviers, but I put it into a separate document for everyone to look at. So these are just kind of interesting. And just to give you an idea, at the heyday, if you will, of common law process, there was about 125 different writs. So what you would do is you'd have a writ for whatever on earth it was that your situation was. And yes, these got bigger and bigger as far as like the list is concerned. And then some of them got stronger and stronger. Like take, for example, the writ of habeas corpus. So, and I'm not going to read all these, but I'm just going to give you kind of an idea. So writ of conspiracy, the name of an ancient writ now superseded by more convenient remedy by an action on the case, which might have been sued against parties guilty of a conspiracy. You think we might want to revive that one? Yeah. Writ of deceit, the name of a writ which lies where one man has done anything in the name of another by which the latter is defamed. Writ of debt, practice, a writ which lies where a party claims the recovery of a debt, i.e. liquidated or a certain sum of money alleged to be due to him. Writ of dower, a writ which lies for a widow claiming a specific recovery of her dower. And anyway, you get the point. And these things just go on and on and on and on and on. And they can all be used as long as you're doing things from a court of record. And we'll get deeper into what a court of record is and how it proceeds through the rest of this. But anyway, the total list of what's in Bouviers as far as the list of writs is in the mega folder. So, all right, so that's writ. And so what's process? So denominated because it proceeds or issues forth in order to bring the defendant into court, to answer the charge against him, and signifies the writ or judicial means by which he is brought to answer. So that's practice. 2, in English law, process in civil causes is called original process, which is what we were just talking about there, about the 3 different kinds of writs. So the original process, when it is founded upon the original writ, and also to distinguish it from men's or middle process or intermediate process, which issues pending the suit upon some collateral interlocutory matter, as to summons, juries, witnesses, etc., and the like. Men's process is also sometimes put in contradistinction to final process, meaning the final execution or process of execution. And it then signifies all processes which intervene between the beginning and end of the suit. And that's from Blackstone's commentaries. 3, criminal cases, the proceeding which is called a warrant before the finding of the bill is termed process when issued after the indictment has been found by the jury. So that's the warrant. So warrants are a part of process. 4, the word process in the 12th section of the 5th article of the Constitution of Pennsylvania, which provides that, quote, the style of all process shall be the Commonwealth of Pennsylvania, close quote, was intended to refer to such writs only as should become necessary to be issued in the course of the exercise of that judicial power, which is established and provided for in the article of the Constitution and forms exclusively the subject matter of it. So what are they getting at here? This is kind of an important point. Let me elaborate on it for a second. So what they're saying is, from a standpoint of certain writs, say high prerogative writs, some of which people in the VSOF are now filing and getting prepared to file. So a high prerogative writ should be done constitutionally, if indeed there is a constitutional provision in the state constitution specifically mentioning it. So I don't think there's a single state constitution I haven't seen that doesn't mention at least habeas corpus and or mentions just as a general overview of saying, sometimes they'll just say high prerogative writs, period. And they'll say such and such high prerogative writs, the Supreme Court of, say, New York has original jurisdiction over all high prerogative writs. That's usually how it's written or something to that extent. And so what that means is that, okay, there's the clause in the state constitution. So you take and use that clause in the state constitution under the law of the case when you're creating your writ. And you're saying, this is the law I'm standing on. I'm standing on my constitution to do this. And the opposite of that, the thing you do not ever want to do, is you do not ever want to use a statute, act, ordinance, or code as your authority. Why is that? Well, as we know here, that particularly the U.S. code is only written for infants. Okay, so if you're going to go use a statutory authority, you're doing so because daddy's allowing you to do it. And I can guarantee you 99.999% of all writs of habeas corpus that are ever sued out in that manner are always dismissed. They never go anywhere. Why? Because the corporate state has discretion and an infant begged daddy to go do something. And on the other case, however, you're doing it constitutionally as a sovereign and demanding that something be done, which again gets back to the aspect of the writs when it said or, right? In the name of the sovereign or the state. That's the whole point. When you're doing an original high prerogative writ, particularly a writ that's obviously not discretionary and of the sovereign's own will, then it's coming from you. You're the one that has the power to do that. And as we'll see in later parts of this treatise, that will come clear as to where the power stems from. Okay, so that's writs and that's process. Okay, so back to where we were here. I think we're down to arbitration, which is right here. So what's arbitration? Practice. A reference and submission of a matter in dispute concerning property or of a personal wrong to the decision of one or more persons as arbitrators. 2. They are voluntary or compulsory. The voluntary are 1, those made by mutual consent. And this part right here, made by mutual consent, this is going to be every single user and license agreement for every single software that you have, and the vast majority of other contracts that you're going to have that you enter into with corporations. They're going to have an arbitration clause in there somewhere. So when they're voluntary, they're made by mutual consent. Now, it still means it's binding. Yes, because you signed the contract or did whatever it is as far as a performance contract that then said, yep, you're bound to this. Like you said, yes, I agree. And then you started using the software. Okay. That's a contractual agreement. You agreed to it. And so then you're bound to that arbitration clause that's in there. And as the Vocational Science of Freedom status docs are, we have the binding arbitration clause within the kill warrant, which specifically states, nope, if you guys are going to administer any part of my estate, which I am the sole lawful executor of, you are bound by a binding arbitration clause that if you attempt to administer my estate in any way, shape, or form, I have the right to take this to binding arbitration for the bond that you're supposed to put up if you go and do that. Because then it's them binding themselves to your contract that you've offered to them, as long as you filed your status docs and as long as you have process served them with the status docs. That's what activates the offer of contract within the documents itself. Because if you do your doc set and you file them on the public record, but you never serve anybody, did they really get notice? Yeah, the answer is not really. Some people have argued to me that yes, they did get notice because it's on public record, but that's really not going to fly in a lot of courts to say, well, it was on public record, and so therefore they should have known that they were bound to the arbitration clause. No. If you really want to bind them, you have to process serve them. And once they're process served, then yes, you have a process service affidavit, which then locks them in to their actions. So, okay, so let me just reread that. Okay, so they are voluntary or compulsory. The voluntary are 1, those made by mutual consent, in which the parties select arbitrators and bind themselves by bond, abide by their decision. These are made without any rule of court, because corporations usually like to stay out of court. And we as sovereigns also like to make sure that we stay out of private for-profit courts that are inferior and do not proceed according to the course of the common law. So is arbitration a good thing for us to use? Answer is yes. Is it going to be easy from the standpoint that even arbitrators, which are usually mostly attorneys or retired judges, are they going to be open to taking out their colleagues? Maybe not. So when you look into arbitration companies, make sure that you talk to the arbitration company, learn who their arbitrators are, and make sure that their slant, if you will, on the court system is as anti-court as we are here, or at least as close to can be. Because if they have any inklings of, oh, yeah, the court system's great or whatever, okay, maybe that's not the arbitration company you want to go with. So just get to know your arbitration company and figure out who their arbitrators are and look up their policies and check them out before you start a claim with them. So, okay, to continue. 3, those which are made in a cause depending in court by a rule of court before trial. These are arbitrators at common law, and the award is enforced by attachment. So that's where the court says by some rule of court that, hey, you guys have to go to binding arbitration before you bring this before said court. And there are situations in which that happens, but I won't get into it. All right, number 3, those which are made by virtue of the statute. 9 and 10, William III. 15, by which is agreed to refer a matter in dispute not then in court to arbitrators and agree that the submission be made a rule of court. So get that. Agree that the submission be made a rule of court. So what's that? You go and you get the award from the arbitration company. An award is a judgment. Okay, so you have an arbitration award. So be made a rule of court. That's when you take it to a court to then do what's called a confirmation. So you confirm the award. And if you want to look at it on the federal side, all of Title IX in the U.S. Code is all about arbitration and about how you confirm your arbitration award and all that good stuff. Title IX is not very long. It's a pretty easy read. And I highly suggest that everybody get familiar with it if you intend to particularly go after the feds in any matter regarding the use of the dock set, because Title IX in the U.S. Code is going to be what you're going to have to take a look at and know how it runs, know how it operates. Okay, to continue. And agree that the submission be made by rule of court, which is enforced as if it had been made a rule of court. There are 2 other voluntary arbitrations, which are particular to Pennsylvania, which I didn't decide to put in here. Okay, so that's that. So that's arbitration. And that's how we're, back in the day, in the Roman time, this is how they did everything. Probably with a lot less fanfare and probably a lot more quickly, I would say. A lot of the things dealt in Rome at that time were done in the market square, pretty much all not by writing, but just by voice. And oration was a skill that was highly coveted by those that wanted to sue other people on a regular basis. And because it was all done by voice and you had to be quick on your feet or you would end up getting run over by somebody who was. So that's a little history of that. All right, to continue. Though the decision was in favor of the plaintiff, yet the state lent no assistance to the execution of the judgment. So when before an arbitrator, the arbitrator would say, yep, okay, plaintiff, the defendant needs to give you back, 20 cows or whatever. The state didn't do anything about it. So you didn't have, Praetorian going out and claiming your cows back. So you had to execute your own judgment. So what's a judgment? Now, this is a pretty long thing, and I made all these little highlights in here literally in Bouvier's Law Dictionary because obviously judgment is one of these important things that we all need to know about. So, judgment, practice, the decision or sentence of the law given by a court of justice or other competent tribunal, which is exactly what we're talking about here in arbitration, as the result of proceedings instituted therein for the redress of an injury. 2, the language of judgments, therefore, is not that, quote, it is decreed or, quote unquote, resolved by the court, but it is considered that the plaintiff recover his debt, damages, or possession, as the case may require, or that defendant go without day. This implies that the judgment is not so much the decision of the court as a sentence of the law pronounced and decreed by the court after due deliberation and inquiry. So think about that for a second. That's the language of judgment. What the court is doing is it's just stating what the law is, right? So read that again. This implies that the judgment is not so much the decision of the court as a sentence of the law pronounced and decreed by the court. Right. The courts just say, hey, yep, that's what the law says. Or, yep, that's what the contract says. And just as it says in this history, as far as what happened in Rome, who is required to go out and enforce the judgment? The plaintiff, not the state. And you can see this in the definition of judgment right there. It's kind of read between the lines sort of thing, but it's there. All right, number 3, to be valid, a judicial judgment must be given by a competent judge or court at a time and place appointed by law and in the form it requires. Now, at a time and place appointed by law. If you write your lawsuit and you say, my court of record is going to be held on such and such day on top of the such and such hill in such and such park. Fine. That's the time and the place that it was appointed. Now, that sounds silly, but there are examples within this treatise where people were holding court in hotel rooms. There was no other courthouse around, no place for them to go. So they held it in a hotel room. Is that valid? Of course it is. If you're a sovereign plaintiff, your court is wherever you go. Always. So can you hold it wherever you want to? Sure. Should you hold it in some place that seems logical? Yeah. But it just means you do not have to hold it in their private for-profit courtrooms. So just keeping that in the back of your mind. All right, to continue. A judgment would be null if the judge had not jurisdiction of the matter, or, having such jurisdiction, he exercised it when there was no court held, or not of his district, or if be rendered a judgment before the cause was prepared for a hearing. So that's an aspect of due process. So a judgment would be null if the judges are not doing what they're supposed to be doing. Now, where can you go after that and find that information? That's your state constitutional courts set up. So you're always going to have your 3 different aspects of government, and the courts are going to be one of them. So go read your original state constitution, see what it says about the formation of courts. And particularly if it says something about courts of record, pay really good attention to that, because then you can throw it into their face constitutionally if they try and say, we don't do that here, or we don't know what you're talking about. Okay. Can you read a constitution? Because you're bound by it. If they ever get uppity with you about, you can't do this, or we got rid of common law. No, you didn't. You just don't like it, but it doesn't mean you can get rid of it. So number 4, to continue here. The judgment must confine itself to the question raised before the court and cannot extend beyond it. For example, where the plaintiff sued for an injury committed by his lands by animals owned and kept carelessly by defendant, the judgment may be for damages, but it cannot command the defendant for the future to keep his cattle out of the plaintiff's land. Now, what do we call that now? When a court orders something not to be done in the future, it's called an injunction. Do courts of record put down injunctions? No. An injunction is only something done in equity. Just remember that. And this is number 4 is showing you flat out that that's what it is. All right, to continue in the blue, that would be to usurp the power of the legislature. A judgment declares the rights which belong to the citizen. The law alone rules future actions. The law commands all men. It is the same for all because it is general. Semicolon. Judgments are particular decisions which apply only to particular persons and bind no others. They vary like the circumstances on which they are founded. 5. Litigious contests present to the courts facts to appreciate, agreements to be construed, and points of law to be resolved. The judgment is the result of the full examination of all these. Facts, agreements, meaning contracts, and law. So facts, basically facts, evidence, and the law. That's it. It's the only 3 things that any court ever deals with. Facts, evidence, and the law, and that's it. So if you're ever trying to think about, well, how does the court work? Facts, evidence, and law. What do they go over? Facts, evidence, and law. What do you need to present? The facts, the evidence, and the law. That's it. Nothing else. Number 6. There are 4 kinds of judgments in civil cases. Namely, 1, where the facts are admitted by the parties, but the law is disputed. That's basically a case in judgment or demur, or a judgment upon demur. Or when you say, hey, I'm going to file a demur, meaning, yeah, I did all this, but it doesn't matter because the law doesn't apply to me. 2, when the law is admitted, but the facts are disputed, as in case of judgment upon a verdict. 3, when both the law and the facts are admitted by confession, as in a case of cognovit actium on the part of the defendant, or nolle prosequi on the part of the plaintiff. 4, by default of either party in the course of legal proceedings, meaning they didn't answer, which is judgment by nil dissent. That means they didn't answer your suit, so it's a default. Basically, nil dissent means he said nothing in Latin. Or non sum informatus, when the defendant has omitted to plead or instruct his attorney to do so after proper notice, or in cases of judgment by non-pros, or in the case of non-suit, where the plaintiff omits to follow up his proceedings. And be very wary of that as far as when the plaintiff omits to follow up his proceedings. When you file in a suit at law in a court of record, the second that you look like you're not following up on your proceedings or you're not moving your case forward, they will jump all over you and down your throat and say, you don't know what you're doing. And they'll try and dismiss your suit that way. I've had that happen multiple times to various people around the country. A couple in Iowa, a couple in Colorado, a couple in a few other states. And it looks like everything's going along fine. And then the plaintiff doesn't do one thing that they're supposed to do regarding due process. The judge just goes, you're not following up. You must not know what you're doing. So I'm going to dismiss your suit. And that's a pretty bad thing because they're always looking to jump down on it. So, yeah, and you're right. And Chad, demur looked pretty neat for getting rid of suits and an alleged defendant. Good point on moving the case forward. Yes, the demur is definitely a way that you can do that. I have templates for demur that are specifically based upon an argument of the 10th Amendment, saying, hey, look, I have the right to do this. I clearly have the right to do it in the 10th Amendment, which are all of the other powers, not vested to the federal government or retained by the states. And I've seen people do it for traffic cases and a few other situations as well. I think the one that went all the way to the 10th Amendment argument that I think went all the way to the Supreme Court was actually, I think it dealt with like a domestic violence case, if I recall correctly, but don't hold any of that. Anyway, it's in my demur paperwork as far as that's concerned. If anybody wants to see the templates, I believe I have the demur template in the right to travel, I believe. If anybody wants it, just hit me up on Revolt and I'll get it to you if it's not in the mega file already. Or just remind me to put it into the mega file for this class because it's something that everybody should have available to them anyway. Because you're saying, look, yeah, I did all this stuff. Yeah, I sped down the road. So what? The law doesn't apply to me. That's basically making it demur. Okay, so that's judgment. So now I'll continue here. Though the decision was in favor of the plaintiff, yet the state let no assistance to the execution of the judgment. Now, again, we're talking about arbitration here. Except by permitting the defendant to be taken and cast into chains. Right. Wouldn't you like to cast a few people into chains, you being the plaintiff and them being the defendant? I sure would. Refusing to treat such an exercise of force as unlawful and punishing any resistance to it as a crime. Now, this is under Roman civil law. Now, is it going to be any different under the aspect of the English common law? Nope. It's going to be the same thing. Because you bring the sword and the sheriff is the one that brings what? His shield. That's why they all wear little shields on their chest, because that's what they're supposed to represent. Defending the law when you're bringing the judgment. All right, to continue. Civil jurisdiction arose from the private arbitration of disputes. The first judges were merely arbitrators. So, seeing as how Roman civil law stemmed originally from arbitration, can they do anything? And what I mean by they is that the way we're using arbitration and the way that obviously corporations use arbitration against us and user and license agreements, is there anything that goes above it? And the answer is no. Why? Because it predates everything else in Roman civil law. They can't get away from it. So just keep that in mind. The exercise of the power of the state developed from the voluntary submission of the defendant, and this became the cornerstone of civil procedure in Rome. 4 periods have been assigned to the development of the Roman law. I won't get into this because they're kind of arbitrary from a standpoint of where they decide to start them and stop them, but I will come down here and talk about this a little bit. So, from the founding of Rome to the creation and promulgation of the memorial 12 tables, there was progress in the matter of summoning a defendant to a court of justice and enforcing a judgment. This is evidenced by the extracts from the 12 tables given below, which constitute all the matter therein contained, interesting and pertinent to a historical discussion of the subject. Now, some of these things you're going to kind of find familiar even today. If the complainant summons the defendant before a magistrate, he shall go. If he did not go, the plaintiff may call a bystander to witness and take him by force. What's that now called? Called a warrant of arrest. If the defendant attempted invasion or flight, the complainant may lay hands on him. Physical force, bring his ass to court. Also still something we have today. 3. If the defendant be prevented by sickness or old age, the complainant shall provide a conveyance, but he need not provide a covered carriage unless he choose. This one's really weird. Number 4, a freeholder or taxpayer whose fortune is valued at not less than 1,500 100 asses shall be a freeholder or taxpayer as vindict or surety for his appearance at trial. A proletary or man of less fortune can find such surety as he can. Now, this is little clause of the 12 tables has always confused me. I don't know if they're literally saying that somebody that's this rich can literally put up somebody else, like one of their freeholders, for surety for them to go to court. It sure as hell sounds like it. Table 2, a party that is in want of witness shall go and cry aloud at the door of his house, thus summoning him to attend on the third market day following. Table 3, in the case of an admitted debt or awards may be made by judgment, 30 days shall be allowed for payment. 30 days. That goes all the way back to the 12 tables. You know, you got 30 days to do this, 30 days to do that. That's why we do notices in 30-day increments. First notice, 30 days. Give them 30 days to do it. Next notice, give them another 30 days. Last notice, give them another 30 days. And you can say in the original notice that I'll give you 120 days total, but you still make sure that you send off and serve the other notices 1, 2, 3, and then do a default. Because this is, again, they're showing 3 times that you didn't do what I asked you to do. In default of payment, after 30 days of grace has elapsed, the debtor may be arrested or proceeded against by the action of manus injectio and brought before the magistrate. So again, what are we doing? 30 days here. Unless the debtor discharge the debt or someone come forward in court to guarantee payment, the creditor may take the debtor away with him and bind him with thongs or with fetters, the weight of which shall not be more, if the creditor choose, or may be less, than 15 pounds. Literally, you weigh him down. This is where we get the term weighed down by debt. This is it. They literally put pounds of chains on your ass. That's where this comes from. The debtor may, if he choose, live on his own means. Otherwise, the creditor that has him in bonds shall give him a pound of bread a day, or if he choose more. Anyway, these are just interesting things. Okay, so let's get back to the reading here. The submission of dispute to arbitration now became compulsory, for while the state did not lay hands on the defendant and bring him before the court, yet it authorized the plaintiff to do so. The proceedings were still oral, meaning we didn't write any of this down, and summoning the defendant was a private act, disobedience to which was not an offense against the law. Apparently, the defendant, if he were the stronger or had friends to help him, could resist arrest without exposing himself to any punishment, and the plaintiff could use force only after calling a bystander to witness that the defendant's refusal to obey the summons. So, come on down to court. Nope, I'm not coming. All right, I'm telling everybody that he should be down at court. All right, still not coming. All right, now you can go lay hands on him, if you can take him. Immediate attendance at court could be avoided if the defendant giving bail for his appearance. So again, where does this come from? All the way back to Rome, paying bail for the appearance. The third of the 12 tables concerns and regulates the enforcement of an admitted liability or of an award. What's an award? From what? Arbitration. If the judgment was not satisfied within, again, 30 days, the plaintiff was authorized to seize the defendant and take him before the magistrate, but this time to show that the judgment was right, and that this was entirely reasonable because the judgment was not the declaration of a court, but of a private individual acting as referee or arbitrator, and thus was invoked the coercive authority of the state. This proceeding to enforce a judgment was denominated an action, actio per manus injectium, and was for the purpose of legalizing arrest. This is why today we still call it an action. Resulted from the defendant failed to discharge the debt. Anybody doesn't know what discharge is? Let's go over that real quick. Discharge. Practice. The act by which a person in confinement under some legal process or held on an accusation of some crime or misdemeanor is set at liberty. The writing containing the order for his being so set at liberty is also called a discharge. 2. The discharge of a defendant in prison under a case, when made by the plaintiff, has the operation of satisfying the debt, the plaintiff having no other remedy. But when the discharge is in consequence of the insolvent laws, or the defendant dies in prison, the debt is not satisfied. In the first place, the plaintiff has remedy against the property of the defendant acquired after his discharge, and in the last case, against the executors or administrators of the debtor, meaning whatever his will has left, you can still file suit against the dead man's estate if he owed you something. Discharged, released, or liberated from custody is not equivalent to acquitted in declaration for malice prosecution. So there's a difference between being discharged and being acquitted. If the judgment was pronounced valid, the person of the defendant was adjudged to the plaintiff. Now get that. The person of the defendant was adjudged to the plaintiff. You literally just got yourself a slave. Unless defendant paid the debt or brought someone forward to guarantee its performance, which was giving security. Oh, okay, so I kind of answered my own question. So literally, he could bring someone else forward that would guarantee the performance or security. So you're literally throwing somebody else into bonded debt slavery. Okay, so what's security? So security is that which renders a man sure, an instrument which renders certain the performance of a contract. The term is also sometimes applied to designate a person who becomes the surety for another, right? Which is what just happened here. Or engages himself for the performance of another's contract. That's where you get security bonds from, right? Or surety. Security or surety, right? Security for costs. Practice. In some courts, there is a rule that when the plaintiff resides abroad, he shall give security for costs, and until that has been done, when demanded, he cannot proceed in his action. Court bonds, anyone? That's what we're talking about here. 2. This is a right which the defendant must claim in proper time, for if he once waives it, he cannot afterwards claim it. The waiver is seldom or perhaps never expressly made, but is generally implied by the acts of the defendant. When the defendant has undertaken to accept short notice of trial or after issue joined means he agreed to be part of the suit, be bound to the court, and usually gave some sort of answer, whether it's a general denial or there's a lot of different ways to answer. But anyway, the point is that when you, after issue joined, that's what that means. And when he knew of plaintiff's residence abroad, or with such knowledge, when the defendant takes any step in the cause, these several acts will amount to a waiver. So that's security and security for costs. And that has a lot to do with where all of these courts creating all of these bonds. This is where you get this from. They've been doing this for a very, 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 very long time under Roman civil law. Okay. All right. So after the collapse of 60 days, the judgment still being unsatisfied, the debtor was brought before the praetor on 3 successive market days, and the amount of the debt publicly declared, after which he may be put to death or sold into slavery. Huh? That's right, my fellow sovereigns. Under the Roman civil law, debt could kill you, literally. So that's how serious that was back then. So under the edicts and praetors, there was much progress in judicial procedure. It was impressed on the citizen that he should be ready to answer in court any complaint brought against him, obviously, because if he didn't come and answer the complaint and the plaintiff got the default judgment on him, well, after 3 successive market days and the amount of the debt publicly declared, after which he may be put to death or sold into slavery, that's kind of serious. Might want to go to court, right? There's a reason why in all the constitutions, state and federal, it states that there shall be no debt prisons. It's kind of the problem. Throw somebody into prison, how is he ever going to pay the debt, right? That's, anyway. And while the summons was still given orally and remained a private act, yet disobedience thereof was made an offense. Want of jurisdiction of the court named did not avail as an excuse, it being required that such plea be made in court. Now, that's an interesting one, but I guess that kind of in a certain way makes sense. Now, how do we do that today? Okay, you go to court only, and if you're doing, and this again is only if you're doing this by staying as a defendant, which I would never suggest anybody do. But anyway, if you're going to one of these private for-profit courts, statute, traffic ticket, whatever, I don't even care if it's murder because they're all commercial crimes anyway. Never, ever go there under general appearance. Never make a general appearance. Every single time that you open your mouth, every single time that you go to the court as a defendant, the first thing you say is, Your Honor, I am here by special appearance only to challenge the jurisdiction of this court. That has to be one of the first things that comes out of your mouth. Otherwise, it's going to make it look like you made a general appearance. You agree to be under the charges, which is, of course, why the judge always does that and asks those questions to you at arraignment, which is where you are agreeing to be subject to this inferior court. You're saying, okay, I agree. to the statutes. I agree that I'm an infant. The way the judge does it, the way the court gets you to agree by verbal contract is he says, do you understand the charges against you? That's all he has to say. If you say yes, you've just agreed to all the statutes and you agree that this is something that binds you, a verbal bond, if you will. You just created that security by telling them that, yeah, you agree to all that. Well, that's the last thing you want to do. You want to appear as the sole lawful executor of your own estate because they've created constructive trust in the private for-profit courts, which is what they're actually charging, not you. And you want to come as one of the people of whatever state you are. And you really want to have your doc set done beforehand on the public record. So then you can file your doc set and say, look, I'm coming here as what I am, not what I'm not what you want me to be. And sure as hell not making a general appearance, and sure as hell not being the trustee of this constructive trust that you just created out of the res of my estate. Now, I know that was a lot to say. I'm not going to get into all of what I just said. Those that have listened to the VSOF for a while already know the vast majority of what I just said and why I said it, because it's what happens in these courtrooms, because it creates them a lot of money, a lot of bondage. So anyway, let me get back to this and we'll continue to understand more and more about what I just said. And if you have to back this up a minute or two and replay what I just said as we go through this treatise, do so. Make a mark, come back to that point, and re-listen to what I just said as to what they're doing with arraignment and everything else and how this all connects back to Roman civil law. That's why I'm reading over this treatise. All right, let's continue. Want of jurisdiction. So you had to go to court to basically challenge the jurisdiction of the court, which in a sense you still have to do now. There's nothing you can kind of put in prior to going to court aside from a motion to dismiss. But then, of course, you still have to get that motion to dismiss on the judge's calendar. And it's usually pretty hard to get a motion to dismiss on the judge's calendar prior to arraignment. I'm not saying it's impossible. It's just not something that people are usually prepared to do that quickly. It is certainly a good thing to get done that quickly because then you can have a motion hearing on your motion to dismiss prior to ever being arraigned, which is where they get you into the trick of the agreement to the jurisdiction of the court. Now, again, you usually don't have that much time. And if you're sitting in jail, obviously you can't do it at all. It has to all be verbal. But in an ideal world, that's what you'd want to do. Okay, so to continue. It was declared to be an offense to rescue a person summoned or to aid in his escape. Before summoning a certain class of people, the praetor's leave was necessary. Okay, I didn't put leave. And leave basically is daddy may I, and yes, you may do that. So leave is a sense to allow something, if you will. So the praetor's allowance was necessary. Nor was it permitted to drag a stubborn defendant from his house. Right? So under Roman civil law, you still can't take someone from their house because a man's home is his castle. If one purportedly avoided being summoned, official notice was given to him to appear, disobedience of which gave the plaintiff the right to take possession of his property. And from this practice arose the enforcement of judgments by seizing the property instead of the person of the debtor. So he literally took over his entire estate. If he wanted to run off and didn't want to do it, you just take a hold of everything. And that was normal under Roman civil law. In the third epoch, the imperial constitutions, the mode of summoning a debtor to court may be described as a reciprocal promise of two persons having a dispute to appear on a given day before a magistrate, with or without sureties. And this was followed by the process introduced by Marcus Aurelius. I highly suggest that everybody read Marcus Aurelius's Meditations, probably one of the best books in the world to read regarding Stoicism, but I digress. By which it was required that a formal notice be served by the plaintiff upon the defendant stating a time for his appearance. Okay, so now, what's a magistrate? A magistrate, law, public civil officer invested with some part of the legislative, executive, or judicial power given by the Constitution. In a narrower sense, this term includes only inferior judicial officers as justices of the peace. Okay. Just remember this. You're going to want to keep this in the forefront of your brain when we get to courts of record. And what is a magistrate? And the fact that they in term includes only inferior judicial officers. Okay, just remember that. 2, the President of the United States is the chief magistrate of this nation. The governors are the chief magistrates of their respective states. And to go a little bit further, a mayor is the chief magistrate of his city. It is the duty of all magistrates to exercise the power vested in them for the good of what? The people, according to law and with zeal and fidelity. A neglect on the part of a magistrate to exercise the functions of his office when required by law is a misdemeanor. It was like that all the way back in 1895, people, and it's still, to this day, the same. If you get a magistrate into a situation where he or she is required to do something by law and they do not do it, you can immediately call the sheriff and have them arrested. Now, are you going to get into a really weird scuffle and just literally be tearing all sorts of gears out of the machinery of this fuckery? Yeah. Are you going to get a lot of crazy looks and people shuffling their feet around being like, oh, I don't know what to do here? Yes. But you have to come armed with the law and armed with what they have to do. If you do that correctly, you can force a sheriff to go ahead and arrest them. And if the sheriff won't do it, you can say straight in front of the sheriff, I'm arresting them. I'm bringing them to your jail, whether you like it or not. You can come with me, or I can call the sheriff of the county above you, meaning your superior officer, or in most counties, you can even get the coroner to come along with you and do it. Because the coroner's, by the way, the coroner's the only one in the county that can arrest the sheriff, just as a side note. Okay, so that's magistrate. So let's continue here. In the time of Constantine, this notice, meaning the public notice to get your ass to court, was submitted to the judge and served by a public officer. So, okay, so when we get to Constantine, it looks a lot more like what we deal with now. Got a summons, do your thing. Here you go. I filed suit. It gets served by sheriff, whoever. They got to come to court and answer. By the time of Justinian, it had taken the form of a written summons containing a statement of the complaint, which was served by an officer under the discretion of the court. Thus, says Mr. Hunter, quote, the summons advanced from the rude form of a legalized use of force through various intermediate stages in which praetors, jurisconsulates, and emperors took part until at length in the reign of Justinian it became an act of public authority and gave the defendant formal notice of the claim made against him. Now, we're going to see in a little bit that under the common law, the issuance of writs followed pretty much that same process. The original means of enforcing a judgment by proceeding against the person of the defendant was ineffective where the defendant succeeded in escaping arrest. This led to the introduction of a supplementary process which authorized the plaintiff to take possession of the defendant's entire estate when he escaped arrest. So, you want to run off? Okay, I'm just going to take all your stuff. That's how that worked out. It deprived the debtor of all right of enjoyment of his property and gave the judgment creditor the right of control and management. And he had the effect of bankrupting the defendant. Now, side note about the bankruptcy aspect. The size of the bond that people have to put up if and when they start to administer your estate after you've claimed it is so high that you will bankrupt them. Unless it's maybe like Elon Musk or someone. Unless you're a 3-digit billionaire. It will bankrupt them. So those of you that have your status stocks done, go read the KW. Go read the section of how big that bond is that they have to put up. And why do they have to put it up? For potential fiduciary malfeasance of the res of your estate. Because why? Because I don't trust these people and neither should you. So make the club so big that they never, ever want to administer your estate again. That's the point. And if they do, that you can bankrupt them. That's also the point. All right, to continue. This entailed the loss of the debtor's political rights and rendered him infamous. No more civil rights. Think about that for a second. They don't have any more civil rights. What are civil rights? Civil rights are granted by government. What are unalienable rights? What are natural law rights? Those are things endowed to you by the Creator. They're not given to you by government. Under Roman civil law, the loss of debtor's political rights and rendered him infamous. That's another way of saying civil rights. This enforcement of a judgment caused the defendant either imprisonment or bankruptcy. Bam, bam. At length, judgment debts were enforced by direct seizure and sale of the debtor's goods by public officials. Animals and movables were taken away first before levying on the land. Slaves, oxen, and implements of agriculture were exempt. Why? Because those things came down to the very food supply of Rome, which then you're fucking around with literally the Roman army. Like you're putting the Roman army in jeopardy, and no one was having that. So the slaves, the oxen, the implements of agriculture stayed with the land. They have to keep on doing what they're doing. They have to keep producing food because we're not going to stop the food production. The sale was conducted by the officers of the court. This now is done. Okay, the equivalent to this now is the appointment of special masters. You can read these in the Federal Rules of Civil Procedure. It's very clear. Go read about special masters and what their powers are. And it's right in the Federal Civil Rules. They're very simple. But you understand that special masters are the officers that account for everything. They do all the accounting. They say, okay, how are we going to sell this? And then they set up the bank accounts, and then they do this, and then they do that. And they make sure that everything is flowing correctly as far as the funds is concerned. And basically, what is a special master? It's basically a judge without the pay. But they're there as kind of like glorified accountants, but they can also sign orders too. So such was the development of the process of execution, which gradually legalized by the state and became, at the time of Justinian, a part of the regular judicial process, being fully transferred from the sphere of individual volition to the domain of public authority. And these are just some of the references that he used for looking into this. You guys can obviously go look and find these. Probably some ones you can probably still find on archive.org. So, okay. Next section, section 2, the English law. Some of these get crazy. The early judicial proceedings of the Saxons were consistent with the manner of the age. That's kind of a nice way of saying that some of this shit was crazy. There were 4 kinds of trials which express mention is made. Trial by the ordeal, by compurgators, I think that's correct, by witnesses, and by trial by the duel of battle. The trial by ordeal was performed in different ways, the principal of which were by fire and water. The former persons of free condition, the latter for villains. Now, the former for persons of free condition. Fire, and then latter for the villains? Huh? Anyway, we'll get to that. The fire ordeal was performed by walking barefoot over burning plowshares. Yeah. Ouch. As Queen Emma, the mother of Edward the Confessor, is said to have done, or by carrying a bar of red-hot iron. Yeah. The innocence or guilt of the party depended on whether the test injured him. In the water ordeal, the accused was denounced bound hand and foot and rope tied around his body, and thus was he thrown into a pool. If he floated, his guilt was established, while sinking was the proof of his innocence. Wait, what? Yeah, you heard that right. If he floated, his guilt was established, while sinking was proof of his innocence. Great. So you just drowned an innocent man. How does that work? Anyway, like I said, crazy. In performing the hot water ordeal, the accused was to plunge his hand into the water if the crime charged was not heinous. But if heinous, then the hand and the forearm were to be submerged. Hot water, I'm pretty sure, meant boiling. Innocence or guilt was indicated by the result of the test being injurious or not. Trial by compurgators was performed by the accused party bringing a certain number of persons who laid their hands on the Gospels, or some relics, and over their hands of the accused laid his and swore that he was not guilty of the crime charged against him. Interesting thing comes to my mind. Maybe not if everybody's seen this movie, but anyway, the movie Kingdom of Heaven, older movie about the Crusades, whatnot. Anyway, there's a part of that movie in the beginning where he takes his son, they're in the woods, it's a bunch of knights just camping out, and another bunch of knights comes up and says, hey, I'm charged with taking your son back to the bishop for trial. And there's a German there who stands up and says, I say he's innocent of the charge. If you say he's guilty, there'll be a fight and God will decide the truth of it. Okay, that is literally what they're talking about here. So somebody comes along and says, I accuse you or whatever, or he's charged with whatever. The other guy says, hey, I say he's innocent, which is the same way of kind of like this, what compunctures are saying. And not that he put his hand on a Bible or anything in the movie, but it's the same idea that somebody else says, no, I say he's innocent. Okay, what's going to happen? Trial by battle. Right then, right there. That was literally how they took care of the vast majority of issues at this time. So anyway, little side note, if you guys want to go watch that, I'm sure you can find a clip of it, of that exact part. Kind of a fun thing to watch. Anyway, to continue, by this act, the persons whose hands were laid upon were supposed to declare on their oaths that the accused had sworn truthfully. This species of trial was applied to civil matters and actions of debt upon civil contracts and was known as wager of law. Trial by witness was the obvious mode for determining the truth of a controversy and was much facilitated among the Saxons in civil causes by reason of the law requiring witnesses to every bargain. Have a contract, got to be a witness. If there's no witness, no contract. It's that simple. Trial by duel or battle was the most honorable and consequently the most common mode of determining disputes. It being the superstition of the times that successful valor was the best test of truth and innocence. This mode of trial was practiced in both civil and criminal matters. How would you like to do that today? Some cop pulls you up for a traffic ticket. You get to court. You say, Your Honor, I demand trial by battle. I'd be totally down with that. Wouldn't you just want to beat the shit out of that cop? Hell yeah. Anyway, musing aside. Such was the inception of judicial procedure in England, which progressed through the trial by certificate, by record, the secateurs, and the assize to trial by jury. The trial of disputes was attended but with little formality. There was but a verbal summons, disobedience to which did not subject the defendant to the harshness and severity of the Roman law. And I just want to make one more point about the whole thing about the trial by battle. So a lot of states, by statute, quote unquote, made it unlawful for people to do trial by battle. And the more current vocabulary word for trial by battle is literally dueling. And a lot of states said, oh, we can't do that. Make a statute. Okay. Can a statute alter or diminish the rights of two sovereigns that wish to go to war with each other? The answer is no. Oh, there's actually two states that are okay. So Janice said there are two states that are still left that allow it. Funny. I think one of them, oh yeah, that's right. We went over that one night. One of them is like a cop, actually, like a police officer literally has to be there witnessing it. I think Texas and Washington. Okay, funny. Yeah, but anyway, and trial by battles obviously slightly different than kind of a duel, but it is and it isn't. A duel is saying, hey, I'm going to take care of this one-on-one. We're not going to go to court. Okay, yeah, Washington's the one that requires a cop's presence. Yeah. I remember when we found that night. It was hilarious. I'm like, really? You gonna have a cop there? But anyway, the trial by battle thing is literally, it's more of a formal way to say, no. This is how we're going to settle this charge. A duel is really more about, hey, we're going to settle a grievance and duke it out or whatever, or swords or pistols or whatever you want. But again, how can a government created by sovereign people decide arbitrarily to take away the capacity of trial by battle? They can't. However, they can administer the infants and say, oh, you little boys, you can't go do that. Right? Well, that's the definition of a person for you. So did they really get rid of it? No, not the sovereigns. But they're not allowing the infants to do it, that's for sure. All right, to continue. It was supposed that all persons in disputes were actuated by the principle of honor that rendered the coercion of the laws not so necessary. Well, that's only if you live in a lawful society. And I made a little note here. Yet now in America, we have nothing but filthy coercion of inferior Roman civil law, giving us all manner of unconstitutional orders and demanding ungodly amounts of fines and fees. Right, because we don't have a lawful society anymore. And I won't get into all the reasons why that's obvious. All right, to continue. As questions of greater perplexity continued to be presented for determination, judicial proceedings became more formal. The oral summons was superseded by a written command to attend court and to answer the complaint charged. Right. They were called writs, were made out under the seal of the king and were tested by the names of the judiciary. Following continued disobedience after service of 3 writs of summons, right? 3 knocks on the door. The land of the defendant was taken into the king's hands and was, after 15 days, adjudged to the complainant. So you have some similarities with Roman civil law, but it's a little bit different. So you had to have 3 writs that were signed and sealed under the king's seal, which obviously it wasn't the king always putting the seal on it, but other people carried the king's seal, which was later called the chancellor, which we'll get into later. But anyway, so it was signed and sealed. So that was the thing. And then you could, in 15 days, take your stuff. The wording of the writ was varied according to the nature of the injury for which a remedy was sought. As I already showed you guys, there was a lot of different kinds of writs, and they were all written based upon whatever your problem was. And in consequence, received a variety of appellations according to their object and occasion, and have amounted in number to approximately 150. Okay, I was pretty close. But few of which are now in use and are to be written of in this treatise. So, the early enforcement of judgments was directed against the body and the lands of the defendant. Arrests for debt was a striking feature of judicial proceedings under the English as under the Roman law. At an early time, the authority was to enforce the payment of a judgment was evidenced by a writ which was named according to the remedy sought, as we just stated. So, conclusion. It is to be observed that the summoning the party to answer to a complaint and enforcing a judgment were originally private acts, which were not authorized, but only permitted by the state. Okay, let me emphasize this here. So, some bank files foreclosure on somebody's house. It goes through foreclosure, and the people don't leave or whatever. And who usually ends up coming to throw people out, like physically move out the stuff? It's not going to be the sheriff. It's going to be the hired security people of the bank, while the sheriff just stands back and makes sure that, nobody shoots each other, which has been known to happen in situations like that, obviously. Okay, so who brings the sword? You do. Who's there with the shield? The sheriff. So, again, they're originally private acts, which were not authorized but only permitted by the state. Because why? It's 2 sovereigns going after their stuff. Progress in the modes of judicial procedure resulted in rendering such acts those of the state, and the issuing and execution of all writs a process are now the exercise of state powers. But notice that it says lowercase s state. You are a lowercase s state if you're sovereign. This fact is important to remember in determining the validity of writs and process and the acts of the officer performed in executing them. Courts have too often been forgetful of this fact, which should constitute the premise of the argument, and have pronounced upon such matters as though the state had no concern therein. Right. Well, the state does sometimes have concern therein, sometimes they don't. But I would wager, no pun intended, that it would be far better for all of us as sovereigns to fully learn the law, learn our power, learn our rights, learn how to adjudicate them in courts of record, and then learn how to execute the judgments. And that goes all the way through from everything from talking about full grand jury indictments of 25 members of the peerage, of treason and sedition and common law theft, to literally putting the noose around the neck and dropping them in the middle of the town square. That used to be a normal thing. Kids used to come to executions. Look, kids, don't steal. You're going to end up like this poor sod, right? Neck snaps off, head just dangles there, or whatever. That was normal. Why? Because when someone steals something from you, you feel like killing them. Okay. That was the way that we took care of it. But we did it in a public way so that it was all shown to everyone. Right? You prove what you're doing. Why does a sovereign convene a court? To prove to the rest of the world that he's right. So, chapter 2. Written process, definition, and kinds. The code summons. Now, I want to make a point here before we get too deep into this. The code summons. Remember, this is This is 1895 that we're reading from here. They're just starting to bring in code. 1895, right? Because in 18 years from this, they'll have their private, for-profit Khazarian mob bank back in place. So what did they want to do before they did that? They wanted to get code pleading back in here. They wanted to sneak in Roman civil law a bit here and there to make it all nice and easy for the transition, right? So just keep that in mind about what time we're reading from here, what the processes used to be like at law, what they've changed them into, and why. Because then you can see behind the curtain of everything that they're doing. You can see how these private for-profit courts even came into existence. And you can see why no one is properly going after them the way that you should to take them down. Because everybody sees them as legitimate, but they have no idea why they're illegitimate. But we'll get through that. Okay, so definition of writ and process. So we gave a definition of written process up top right in the beginning because I didn't want you guys to kind of going through this without knowing what it is. But now the author will give another full definition. The English word writ is of Saxon origin and indicates the progress of judicial procedure which resulted in substituting written for oral forms and gave to the formulae the name of writ, which was called breve in Latin because it contained briefly the manner of complaint alleged against the defendant. And breve turned into what? Brief. Process in a general sense means the entire proceedings in an action or prosecution. Real or personal. Now, I should pause here, okay, in case anybody doesn't know who's listening to this. Real actions or personal actions. Okay, what is that? Real action, aspect of land, real estate, property, so on and so forth. Or personal. Personal are the harms, torts, that sort of thing. This is the signification of the word as used in the phrase due process of law, meaning those rules and principles which have been established by our jurisprudence for the protection and enforcement of private rights. That's it. That's what due process of law means, for the protection and enforcement of private rights. That's what it is. That's why it's so important that whenever the corporate state does anything incorrect as to statute, you should know exactly what they have to do. And if they don't do it exactly to a T, or if they screw up anywhere, you can stop everything and say, nope, I move to dismiss this entire charge, whatever it might be that you're facing, because so-and-so did XYZ or didn't do XYZ within the time that was required. You can get them on speedy trial a lot of times with that. You can certainly get them when it's a traffic ticket and you get all nicey with the clerk of the court and then change the date. Say, oh, I can't make that date. Can we change up the date? Right. And do it as soon, like kind of as close to court as you can with getting away with it. It'll get changed. And guess what? More than I think 80% of the time, the cop that's supposed to show up to give his testimony doesn't show up when it gets rescheduled. So there's just a little trick for everybody. But again, this is all due process stuff. So once you learn due process and what they have to do and they don't do it, well, then you got them. I'll give you a really good example of due process. It's something that they never do. And I've gone over this with Viper. I've gone over this with everybody regarding the right to travel because they never do this correctly. And it's in all of the state statutes that they have to. Okay, what am I talking about? I'm talking about arrest. Pretty much every state says in the criminal proceedings of the state, and you can just look these up in the statutes, it'll be criminal procedure. It says that upon arrest, with or without warrant, meaning doesn't matter if the guy, say the cop literally witnessed them do something, or he's pulling you over for a traffic ticket, or you're going 100 miles an hour in a 75, whatever. Upon arrest, with or without warrant, the arresting officer shall take, so it's not up for opinion here, shall take the accused before the nearest and most accessible magistrate within that county. Period. And that's pretty much what all of them say. Literally what I just said, verbatim. Okay, what does that mean? It means if that stupid pig turns his steering wheel towards a jail, instead of towards the house of the nearest and most accessible magistrate. Meaning if the magistrate is 2 blocks down the fucking road, that's where he has to take you. I don't care. That's what the statute says. Why? Because it comes originally from common law. Common law due process. Upon arrest, if you arrest somebody, you have to immediately find a magistrate that will write it out and create what's called a warrant of commitment. Why did you take this guy's liberty? Well, because he stole a woman's purse and 5 people saw it and they're all here. Okay, that's good enough. I'll sign a warrant of commitment. Then it's signed. The guy either puts a bond or he says, yep, you can take him to jail now. And I'm taking this from an example that if you literally walked up to a magistrate's house and did it on his front porch, that would be how it would have to go down. And strangely enough, you go back far enough in time in the 50s and 60s out in the rural areas, that's exactly how it was done. You would literally sit down at the magistrate's, kitchen table with the cop next to you, explain what the hell happened or not. And then he either created a warrant of commitment and the cop took you off to jail or not. But they knew back then that they had to do that. Why does nobody do it now? It's because the judges don't want to bother. They're all Luciferian fucks that are just there for the money. They don't care about law. They sure as hell don't care about your rights. So not one single time that you're ever arrested does that happen. And it's very, very important, specifically if you see the little dot blinking on the cop's body cam. Make sure that you say that into the body cam because he won't have the slightest fucking clue what you're talking about. Say, I demand to be taken directly before a magistrate. And he'll say, okay, you're going to jail. All right, well, for the record, I demand to be taken directly before a magistrate. And then say it one last time, like, somewhere during the path of going to jail. Just for the record, again, I demand to be taken directly. And then he'll say something like, yeah, shut up. I know. You already said that. Okay, just making sure. You say that 3 times. That's it. I don't care what the fuck. Even the charge is murder. It doesn't matter. Technically, that cop becomes a trespasser ab initio. And on top of it, and here's the fun part, he's guilty of aggravated kidnapping. Why? Because he displayed a deadly weapon whilst he was kidnapping you to take you to a place that he didn't have any lawful authority to do so. Fuck you, buddy. You just committed aggravated kidnapping. Now, you want to go start convening 25-member grand juries and bringing aggravated kidnapping charges against every single cop that's out there? Go ahead, because I can guarantee you that you'd be right in doing so. Like I said, if anybody doesn't believe me, just go look up the statute. Now, of course, is statute Roman civil law? Yes. However, it's from the common law that we get this. So, if they're not following due process, which that is definitely a part of due process, explaining to a judicial officer why you took somebody's liberty is definitely an aspect of due process. Guess what? Case dismissed. And that's what it says in Gerstein Pugh, which is a Florida case. And there's another one out of Texas, which is Heath versus Boyd. Both of them still good case law. Both of them absolutely say what they say. I won't get into the history of them. I could literally recite them verbatim, but I think I've already done that in other classes, so I won't bother doing it again. Pretty sure I went over it in the right to travel classes in one of them. So that's what it is. That's a very good example of due process, and it's very important to know these things because this is the reason why we don't just go kill each other. Court and laws are there to create situations of which a society can logically govern itself, and which a society has the capability and the methods to remove harm from their society that's not arbitrary, that is public, that is logical, and that is structured. I have no problem with following the rule of law as long as everybody else does too. That's kind of the thing. Because once you live in a lawless society in which no one follows the law, no one follows due process, okay, am I bound to do so? The argument could be made, and not really. So, be careful what you wish for. But anyway, to continue. In a stricter sense, process is a generic term for all writs which are called judicial. It is in this significance that the word is to be used and discussed in this treatise. I'll just there's a little footnote here, one, so I'll just read the footnote. Verbal process. A true relation in writing in due form of law of what has been done and said verbally in the presence of a public officer and what he himself does upon the occasion. It is a species of what? Inquisition in office. Right? That's why we do an inquest. That's why we do a judicial coroner inquisition in the status doc process. So just know that. So I'll just reread this again because this is how they're going to be referring to process throughout the whole thing. In a stricter sense, process is a generic term for all writs which are judicial. It is in this significance that the word is to be used and discussed in this treatise. The terms writ and process are often used as synonymous, which is entirely proper. But process being a generic term, the word writ is correctly employed to indicate a particular kind of process in a civil suit, as the writ of summons, the writ of attachment, process in a criminal action being denominated a warrant. Okay? So we have process in both criminal and civil, that they have different names. All writs are process. That which brings an instrument within the meaning of one requires it to be included in the definition of the other. In the construction of constitutional and statutory provisions, there has been great occasion for considering the meaning of the word process. And as the bar has often engaged in the controversy as to what is included within the term, so the bench has not at all times been consistent and correct in declaring what it properly means. So you're going to get into due process arguments. Make sure you have very good, solid due process case law to back yourself up, and also constitutional requirements, right? And in the case of idiot statutory people, the ones that have to follow that, cops and whatnot, bring the statute. Say, here, this is what it says right here. And then here's cases that prove that this is what the legislature meant when they wrote this, that they weren't just making this up willy-nilly. This is the rights. This is where the rights come from, so on and so forth. Which, by the way, the whole purpose of taking directly before the magistrate upon taking someone's liberty, that goes all the way back to the Magna Carta. So 1215, people. But to continue, it is of the very first importance to definitively understand the full and correct definition of the word, which is why I give it all to you guys at the start of this treatise. A writ process is an instrument in writing, in epistolary form. Breaking up that word's messing with me. Running in the name of the sovereign of a state, issued out of a court of justice or by a judge thereof at the commencement of an action, or at any time during its progress or incident thereto, usually under the seal of the court. This is why I have you guys make your house seals and then record them on the public record. Duly attested. This means so that it comports to both being correct as to statute and common law. That's what duly means. And directed to some ministerial officer or to the party to be bound by it, commanding the commission of some act at or written or within a time specified, or prohibiting the doing of some act. So notice up here, it did not say the sovereign state. It said in the name of the sovereign of a state. And notice the lowercase s. Right? This is the closest you're ever going to get to an attorney actually telling you the truth. But it's hidden. It's basically occulted, unless you know what you're looking for. Right? That little tiny bit of difference. Name of the sovereign of a state. Not the sovereign state, which is what it pretty much states in all of the second and third and fourth constitutions of state constitutions that came afterwards when they're creating their little corporations. Because the attorney wants to pretend that the state is sovereign, meaning the corporate state sovereign, and they are most definitely not. Section 5, kinds of writs, their nature. The principal derivations of writs under the common law are original, judicial, prerogative, and of right. Original writs, not now in use, were mandatory letters from the king sealed with his great seal and directed to the sheriff of the county wherein the injury was committed or supposed to be. It was issued on application or suit to the crown, the foundation of all justice, well, haha, why would the attorney put that in there? Well, okay, in England, but not in America. The crown is certainly not the fountain of all justice. Was the foundation of the action and named according to the remedy sought. Again, the various different kinds of writs, which would be, of 150 different kinds. So you created the writ based upon whatever you were looking for. This writ was not included within the meaning of the term process, meaning the original. Okay. The author believes that this definition of the word writ is sufficiently broad to include such instruments issued under statutory provisions, which may permit the omission of the seal and other variations of a allied nature, I don't know that word, and yet strict enough to be within the common law meaning of the term. The cardinal requisites are that the instrument issue from a court of justice or a judge thereof, that it run in the name of the sovereign of the state, again, repeating what I said above, that it be duly attested, but not necessarily by the judge, although usually, but not always under seal. Yours, however, anybody that's created their house seal, make sure that if you create a writ, make sure that you seal it with your house seal. And that it be directed to someone commanding or prohibiting the commission of an act, meaning sheriff or whatnot, or the coroner, or one of your appointed marshals of your court of record. They also have the capacity to do this. It is and must be the mandate of the court. The definition of the word commonly given is subject to criticism and has led to much confusion. The statutes of the several states usually require process to be under the seal and attested by the clerk of the court. Process issuing from a court of record must be under seal. This is the reason why I specifically underlined this and why it's important for you guys to understand what it is in the basis of under the common law. The principle derivations of writs under the common law. Okay, so what do we got here? We got a court of record. What on earth is a court of record? A judicial tribunal having the following attributes, A through E, defined below, and authority cited. Okay, there we go. All right, court of record. So, a court of record is one, a judicial tribunal having attributes and exercising functions independently of the person of the magistrate designated generally to hold it. Independently. So, in a court of record is the magistrate, or, well, there wouldn't even be a judge because it has to be a magistrate. In a court of record is the magistrate the tribunal? The answer is no. All right, who the hell is the tribunal in court of record that acts according to the course of the common law, which is B? Okay, it's either the 12-member jury of the peerage, 12 sovereigns get together and then determine what the law and the facts will be, which, by the way, is called a general verdict. So if you ever really, really properly want to have a court of record, file your suit against someone as a plaintiff in a court of record, demand a jury trial, and demand that the jury produce a general verdict. That will strip that judge of his power to determine what is and what is not the law. Absolutely 100% out of his hands. No more would he have any power whatsoever. He can't be a trier of fact, which they like to try and do all the time, and he cannot judge the law. So if you want a true, absolute true court of record proceeding to the course of the common law, and you want the jury to act properly, that's what you do. Now, if there is no jury, who is the tribunal of the court of record? It's the sovereign plaintiff. So if the defendant doesn't demand a jury trial to protect himself from the sovereignty of what he's coming up against, in a court of record, the tribunal is the sovereign plaintiff. Now, are any courts nowadays, since there's been so far and removed from common law from what we're reading, because remember, again, this is 1895, are any of them going to understand that or even go along with it? Probably not. They'll probably think you're crazy, and they'll probably think, what are you talking about? You can't do that. Actually, I can do it, and here's all the law, and so on and so forth. Now, is there still going to be a problem going forward? Probably, which is why I specifically created the doc set to be able to go through binding arbitration, which is a hell of a lot easier than trying to convince a black robe priest of El that you're actually the boss in his little room and not him. It's hard to teach old dogs new tricks, and for black robe priests of El, it's impossible. Okay, to continue. C, its acts and proceedings are enrolled or recorded for perpetual memory and testimony. That's usually what people think about a record. D, has power to fine and imprison for contempt. Right. If you don't do what I say, I get a judgment. You don't give me your stuff. Fine, I can throw you in prison for contempt. of not doing what the court said to do. And E, generally possesses a seal. So don't forget about your house seal. These are the 5, controlling factors of a court of record. So now, let me just make sure that the PDF you guys can see. Okay, good. So this is what it is. This is a court of record. That's important to know because it says process issuing from a court of record must be under seal. Got it, guys? So make sure you use your house seal. The word seal, the word implies seal. Writs from courts of limited jurisdiction, right? Inferior private for-profit courts, not proceeding according to the course of common law, which is what that is. Writs from courts of limited jurisdiction are within the definition of process, though not under seal. So, do you usually ever get anything from the court that's sealed? Not usually. And if they do seal it, are they actually acting as a court of record? Again, not usually. So down here, judicial writs or process are those which are issued out of the court and under its seal and not under the Great Seal of England. Again, I don't even know why they're bringing this up considering it's American jurisprudence, but so be it. They were testated in the name of the judge of the court out of which they issued, were founded on the original writ, and constituted the next step in the suit after suing out the original writ. By the way, a certain little standpoint here. I don't know if it's going to get into this or not, but when they're talking about the original writ, I just want to make it clear as to how this process happened. So you as a plaintiff would write up the original writ, you'd file it into the court, which creates and starts the case. And what has to be connected to the writ, or when you file it into the court, is the declaration. And a declaration is what you file at law in an action. There's 7 parts to a declaration at law, and there's 9 parts to a bill in equity, but I don't want to get into all that right now. Just to know that the original writ gets attached with the declaration, with the original action. Then all that the sheriff goes out and serves onto the defendant is the original writ, which says you're summoned to court. This is what you're being sued for. You have so many days to reply, and basically the suit or the documentation is sitting at court at such and such court. Go find it there. And then it was the defendants go to the court, read it. Okay, what the hell's going on here? Right. Nowadays in civil, if you ever sue anybody in civil, you have to present the whole entire case gets presented. Well, let me retract. Not the whole entire case, but the original whole complaint has to be given to them when they get served. So, or else it's not considered legitimate service. Okay. So all writs issued after the original were called process. In the practice of the present time, the original writ having fallen into disuse, all writs or process are now properly denominated judicial. As of old, so are they now called original, mens, or final process. Terms of convenient designation, but not of necessity. The summons being the original, the execution, the final, and all intermediate writs being included in the term mens process or middle process. By the word mens, it has been and is sometimes now used to denote all process except final process, the writ of execution. The terms mens and judicial have also been used to distinguish between writs which precede the execution and the writ of execution, the word judicial being employed to designate the writ of execution. Prerogative writs, sometimes denominated in statutes, quote unquote, state writs, are those which seek remedies of an extraordinary kind and are granted by courts in certain cases, but never as a matter of right. Now, just stop and pause about sentence construction here. Why did they write it like that? Okay, let me go through this very slowly. Prerogative writs, comma, sometimes denominated in statutes, quote unquote, state writs. Right. So we just talked. All right. So they open up the sentence with prerogative writs, sometimes denominated in statutes as state writs. So they just changed the subject of the sentence. So state writs are those which seek remedies of extraordinary kind and are granted by courts in certain cases, but never as a matter of right. That's what a state writ in statute is. This over here, the thing they started the sentence with, these are granted some are granted as a matter of right, but not what they changed the sentence structure into being. Okay, so you have to be very conscious of how attorneys write when they do fucking sneaky shit like this. Okay, so anyway, to continue. Such writs, meaning the statutory ones, being a direct intervention of the government with the liberty or property of the subject. Uh-huh. They were so named because they called into exercise the extraordinary power of the crown. See, again, we're talking about this is statutory stuff. So they're still sticking to this subject matter, not the whole totality of what a prerogative writ is by a sovereign. Exactly. Tricky bastards. The principal writ of this nature are also of certiorari. This is what's called a cert. These are the ones that you appeal directly to the Supreme Court based upon matter of constitutionality, federal constitutionality. Prohibition, which is a writ saying, hey, you shouldn't be doing that. And these are the reasons why. Procedendo men. I don't know what this one is. I've never heard of this. Okay, so mandamus, quo warranto, and habeas corpus. These are the ones that I know. I don't actually know what that is. I should go look that up. All of which are now in general use, except this one, of course. All right, the functions of which are performed by the writ of mandamus. Okay, all right, so be it. All right, so then we're going to skip down to section 6 as defined by courts. We wish now to call attention to particular adjudications wherein the definition of the word process is considered and declared in reference to certain instruments, and the assertions now to be made are on the authority of the cases cited. Statutory authority, here we go again, to a constable to, quote, serve any writ or other process, close quote, empowers such officer to levy an execution on and sell the land of the judgment debtor. The word process, as generally used, is understood to mean a writ, warrant, subpoena, or other formal writing issued by authority of law. All right, so now we're going to skip down to the next highlight because, again, I'm going to skip through this kind of quickly. A certified copy of a decree ordering a seizure of property is not process. An action by an officer thereunder is without authority. So, if some pigs give you a copy of a warrant, is that valid? The answer is no. A certified copy of a decree ordering the seizure of property is not process. Process has to be signed, and if it's by a court of record, it has to be signed and sealed. If a cop gives you a warrant and it's not signed, it's not a valid warrant. I don't give a shit if it's on their computer. Makes no difference. Unless a magistrate or judge is willing to go behind their full commercial liability and sign a fucking warrant, it is not valid. Why? Because that's exactly what they're doing. They are going behind their full commercial liability to sign that thing and saying that, yes, everything was done proper. I'm actually acting the way I should be acting in the office of which I'm holding. Right? Does anybody think it's ironic or find weird, that Viper has found, what is it now, up to 43 fucking different judges that don't have oaths and bonds in Florida? Why do you think that is? And why do you think they never sign anything? It's because they do not wish to be held by any oath or bond. They do not wish to abide by the law, and they are certainly not doing so. So, on that, I think I'll stop for the night, and we'll continue this on next Saturday. Okay. So until then, hope you guys have a good rest of your week. And until next time, as always, stay safe and stay sovereign.